big deal.
All rise. For appeal for the 5th District of Florida is now in session. Colonel C.L. Lawson, Judge, presiding. Offer to say this is for the court are under your attention and your word. The God of the United States of America, State of Florida, and His Honorable Court. You may be seated.
Good morning and welcome to an oral argument session at the 5th District Court of Appeal. I'm Alan Lawson. Let me introduce the rest of the panel. We have Judge Vincent Torpy and Judge Carrie Evander. We have 5 cases scheduled for today's docket, and we're going to take a break after the 9 o'clock docket, so after the third case, Loeffler versus Patricia Northley. And as is our custom at the 5th District Court of Appeal, at that point when we take our break, the judges will join any attorneys who want to join us for coffee in the Lawyer's Lounge. Those of you who have arguments beforehand, we understand that you have busy schedules. If you need to get back to your practice, that's fine with us, but if you want to wait, we'll be there and we'll greet you at that point. So we're ready to go with the first case on the docket. This is a criminal case. Each side will have 15 minutes. Joseph LACH versus State of Florida. And if you'll let me know as the appellate whether you want to reserve some time, I'll sort of give you an indication when you get to that time point, but you do have 15 minutes. So.
Good morning, Your Honor.
Good morning.
Good morning, all of your honors. Thank you for allowing me to argue before you. I would like to reserve 3 minutes at the conclusion of my argument. This case clearly involves a relatively unique circumstance where the appellant is seeking relief from claimed ineffective assistance of counsel on direct appeal. Mr. Lack was convicted of sexual battery on a physically helpless person in Seminole County Circuit Court. He was accused of having intercourse with a young woman of about even age who was a friend of his. Who had, by prearrangement, come to his home, actually his parents' home, after a point in time when she discovered and he revealed that he had broken up with his girlfriend. This young lady had a boyfriend who she later married, but he had been shipped off to Iraq.
Ask you this, Mr. Hugo. In reviewing the cases in preparation for oral argument, did you happen to look back at the Geiger case?
Yes, I did. I found this is the case involving the person who was a sole caretaker of Alzheimer's patients at a nursing facility, and we see here where this was also a trustworthiness hearing issue. The court in this case did actually hold a hearing. This individual had made a confession, or what was similar to a confession to, I believe, church elders, a number of them, indicating that he had committed a sexual battery of some sort with some patients who he was charged with taking care of.
And am I correct that in that case the only evidence was his confession? There was no evidence outside of his confession? Well,
it was very interesting corroborative evidence that was suggested by the trial court. He was seen to go into this room where the victim, the alleged victim, was said to be, and then close the door behind him. When he emerged, the victim, an Alzheimer's patient, was seen to have different trousers on or pants on, and also the underwear had been reversed.
And that's what I was asking, because as I read that case, and maybe I read it too quickly and I didn't bring it up here with me, but I thought that in Geiger that the court was talking about U.S. versus Lee, and those facts, those circumstantial facts that you're talking about were in that case and were found to be sufficient to corroborate. And they were contrasting that with the facts of Geiger where there were no independent facts that would corroborate.
Well, I'm simply reciting the facts that I know to be the facts that were cited as corroborative by the trial level court in supporting the introduction of the confession. The second DCA, 2002, found that these were insufficient corroboration, and thus statements of the defendant were deemed to be inadmissible. I had thought that the result was that charges were ultimately dismissed. This was not sent back for another hearing or a new trial. I believe that was the result. Yes, it was reversed. I see, and I want to go right to the center point here of this case. I believe that we have to show that there are unique circumstances here, that the standard that's set out, I think, in the Corso case have been met. Namely, we have to show that the mistake was obvious on the record, on the appellate record. We have to show that the prejudice was indisputable, and we have to show that a tactical explanation for the behavior of trial counsel was inconceivable. Also, when we read Corso, we see that courts have been more inclined, when these standards are met, to grant the relief suggested by the appellant when a fundamental error is indicated as having been committed by the trial court or by trial counsel. They cite cases, for instance, where trial counsel failed to object to repeated instances of inflammatory comments made by prosecutors. In this case, we have an absolute requirement, it seems, by a plain reading of the statute, 92-565, I believe it is. We have a mandatory...
I guess I've never seen a case where the victim's testimony, when a victim was available to testify and testified to facts that would tend to corroborate what the defendant said, was not found to be trustworthy. And that's why I was curious when I read your brief and saw that you had said that Geiger included facts that would tend to corroborate, and yet the second DCA still found that was not sufficient. But I actually did pull it, and I'm looking at it, and the facts that you cited are facts from United States versus Lee, which are talked about at page 675 of the Geiger case. And in there they say that in that case there was corroborating evidence of the defendant carrying the victim to the bedroom, closing the door, and barring entry, and those are the kind of corroborating facts that are sufficient to show trustworthiness. But then they say, as I read this case, that in Geiger itself, the only testimony that they had, or the only evidence, was the defendant's statement. There was nothing else to corroborate, and that's why they threw it out. So other than Geiger, do you have any other case where a victim's statement to facts that would tend to prove or show that the defendant's confession was accurate or not sufficient to corroborate as trustworthy?
We take a look at BP, if you would, the case from the 5th DCA. This is a juvenile case, obviously. We have a confession that is made to reflect that the defendant commits a certain act that varies somewhat from the act accused to have been committed by the victims. Now, so there was some corroboration that a type of sexual act had occurred, corroborated by the victims, who were not, strictly speaking, unavailable. Those allegations did vary, of course, from what the juvenile admitted to. But even that, under those circumstances, I think this was Judge Harris, writing for the court, indicated that this was insufficient. There were other grounds set forth in the BP case where this court found that there was that the statement that the juvenile had made was inadmissible on other grounds, but even at that found that there was no hearing that was held to determine the trustworthiness. Even if a hearing had been held, it wasn't going to be rendered admissible at any rate, for not only that but other reasons. So there is another case which indicates some kind of corroboration but was deemed to be insufficient. It was this this very court. I'd like to ask this court to focus a little bit on my argument. It basically goes to the representation that the element of the crime that would not have been successfully corroborated was the disability aspect of the...
Isn't that the point of 92-565? In other words, there's generally a corpus delicti requirement which requires the state to put on evidence to establish each element of the crime prior to using the defendant's statement. And this statute was enacted as an exception to the corpus delicti rule, and simply requires some evidence that tends to establish the type of harm that's being charged. It doesn't require, I mean, that's the whole point, is that under 92-565, the state doesn't have to establish independent proof or corroboration of each element. So why is it relevant or that there's only, your argument is there's one element of the crime that the victim's statement doesn't corroborate. To me, that means, or that screams that, well, then that's certainly enough if it corroborates all other elements. That's certainly enough under 92-565, because that's the whole purpose that the statute was enacted.
When I look at the trustworthiness hearing rule, and I look at the corpus delicti rule, the predecessor, if you will, to that, I try to think of it in much more simple terms, and those terms are the courts don't want people to be convicted of crimes that they have confessed to, which in actuality didn't occur. And I think that the structure of 92-565 is designed to prevent that very thing from happening. And so when you ask the question of me as to what's the relevance of the issue as to whether she was asleep or not, I want to answer you by saying that there is, not getting ahead of myself to a trustworthiness hearing, but I do want to assert that there is a series of facts both before, during, and after this incident is said to have occurred, which give rise to a high likelihood, perhaps a finding of preponderance of the evidence, that this young lady was not asleep.
But didn't she give that testimony that she went to bed, she had pajamas on when she went to bed, there were only two people in the house when she went to bed. When she woke up, her pajama bottoms had been removed, that she felt in the vaginal area that's wet and sticky and sore. I mean, isn't that evidence that she was asleep? You know, that she went to bed and then she woke up and circumstances had changed.
I think that is fundamental evidence that by virtue of the fact that she showered immediately, she didn't complain of it, she was left alone. That goes to
her credibility later on as far as her, but as far as evidence, that she gave that would tend to corroborate that she was asleep, why isn't that evidence? She says, I went to sleep and I woke up the next morning. I mean, isn't that evidence that the person was asleep?
Well, what I'm saying is the trustworthiness of the defendant's statement in the controlled phone call that she was asleep. He makes the assumption in that controlled phone call in responses to her questions that she was asleep, and when he realized that she was asleep, he stopped doing whatever he was doing. That's the aspect of the statement which I believe, and I'm asserting here, would not be found to be trustworthy, because all of these other...
You have about 2 minutes left.
Yes. All of these other factors, the specific facts of this case, before, during, and after, would lead a reasonable person to believe that indeed she was not asleep, that she felt pangs of guilt when the party occurred 8-10 hours later, when she was seen by her lieutenant, who was a very close friend of her now husband, in compromising circumstances with Mr. LACH, and she needed to come up with an explanation for that. She didn't issue any complaint, didn't call the police, didn't call a friend, didn't didn't make any reference to Mr. LACH. For all of this time that had passed up until that point in time, when she was seen by the lieutenant who was her supervisor, very close friend of her husband, who was off in Iraq, she never made any comment to her husband, to her boyfriend then, that she was going over to this gentleman's house, that she was going to spend the night, in his bed. I believe that there is a reasonable conclusion that we can come to, that her assertion of being asleep when the sex acts occurred only came about at a later point in time, when she was compromised by the people who came to the party, saw she was having a good time, was in physical closeness and proximity to Mr. LACH, and at that point in time, she needed an explanation, and the explanation was that she thought she had had some kind of sexual activity with him. It was only later on, when she gets to the police station, that she gives these indications, after having the offense described to her, that in fact she was asleep. And so, under those circumstances, I believe that the trustworthiness hearing should have been held, and it was not. It's mandated by the statute, and it was error by trial counsel. Thank you.
May it please the Court. I'm Rebecca Wall, Assistant Attorney General representing the state in this appeal. Yeah, it's absolutely clear that the victim did need an explanation, because she had no clue what had gone on. She had been asleep the whole time. So, yeah, she did need an explanation, and she got the full explanation when they did the controlled call. This Court has said in MacArthur that, MacArthur v. State back in 2001, that the evidence necessary to prove corpus it just has to be substantial evidence. It doesn't have to be uncontradicted or overwhelming. The victim's testimony made it pretty clear she had no idea what had happened because she had been asleep. I don't know that she ever said the word asleep, but she clearly was asleep during this time, and that was her claim. She knew something. She knew quickly, or fairly soon after she got up, that something was wrong, and it was of a sexual nature. She was sore in the vaginal area, was wet and sticky, and her pajama bottoms were missing. Her pajama pants were on the floor. She was on the opposite side of the bed from where she woke up, or where she went to sleep. So she knew something had gone on, but I think it's also clear she recognized it was a serious situation, and to make an accusation without knowing what had actually gone on was a serious thing, and so she didn't immediately make an accusation. What concerns the state is with this particular case, it's clear on the face of the record there was no objection to the admission of the phone call. The issue wasn't preserved for appeal, and this Court has held that that's not fundamental. The admission of a confession without adequate proving of corpus is not fundamental. What we're seeing is an ever-growing trend of an attempt to raise a non-preserved issue by arguing that there was ineffective assistance of trial counsel on direct appeal. And the courts have made it very clear that there are very few unique situations where it's appropriate to look at that on direct appeal. One is that the deficiency is obvious on the record, not just apparent if you look hard enough, it's obvious on the record. Second, the prejudice has to be uncontroverted. And third, a tactical explanation is inconceivable. If the Court would look to see if there had been an objection.
Let me just ask something. I hate to break your pace there. I'm just kind of curious about this corpus delicti rule. Does the corpus delicti, the prohibition against admission of admissions or confessions, does that apply to any statement that the defendant made at any time, or does it apply to, or is it only intended to apply to police interrogations?
The wording in the statute itself, Judge Torpy, is the defendant's memorialized confession.
Suppose the defendant makes an extemporaneous remark during the commission of the crime, which under the hearsay rule is an admission, even though it may not be a confession, it may not be inculpatory, it may be exculpatory, it may be anything, it may be some extemporaneous statement that the defendant makes. during the course of the crime. Does the corpus delicti rule prohibit the admission of that statement?
I think what you're asking is...
Before you get to 565, I'm just asking you about the...
So apart from what the statute would identify...
565 is intended to be an exception to the rule that the statement is not admissible.
Right. And clearly the statute relates to memorialized confessions, which I think would take away or would not include the victim's testimony of what she heard when she participated. It would just be the tape that they wanted to play, the memorialized.
That's why I was curious about it, because I always thought that the corpus delicti rule was a rule that applied to confessions. You know, the defendant, the purpose was, like counsel says, to preclude somebody from going into the police and confessing to a crime that they didn't commit and being convicted based solely on that confession. But I mean, a confession and admission are two different things. An admission can be exculpatory, can be inculpatory. Under the hearsay rule, it's anything that the defendant said at any time. This controlled conversation is not under police interrogation. It wouldn't have any indicia of untrustworthiness because of police browbeating somebody into confessing or police tactics or anything like that. It's just a conversation that occurred at some time that happened to be recorded under supervision of the police. I'm just curious as to whether that's even the type of a confession or admission that is contemplated by the corpus delicti rule.
And I would say no. I would say that what's contemplated would be exactly as you characterized. The purpose is...
And you all didn't argue that, so this is just my curiosity. But,
it wasn't argued because there was...
I know there wasn't. It wasn't.
The issue was never brought up. It was never objected to.
Brought up below, right?
And I think that, in a way, the defense used or intended to use this conversation to support their defense that he thought he had implied consent, because there is one reference to cuddling at the end of the conversation.
So it would be your position that the second DCA erred in a pretty significant way in Geiger because they reversed a conviction when the defendant in that case had made statements to a clergyman that were used at trial. It wasn't a law enforcement confession in that case.
The problem with Geiger, and I think...
But I'm addressing Judge Torpy's point.
Right. Geiger is... I think Geiger is one of those cases that falls exactly into that category that the corpus rule was intended to protect.
You just said it was only intended to protect police interrogations. Or confessions
not
made
police
during
interrogations,
police interrogations.
But clear confessions to a crime, a confession, not just an admission or a statement that could be equivocal or ambivalent. I think whether it's I don't think it's the circumstances of the confession. I think it's the substance of the confession. A confession that would be the sole basis of a conviction. And in Geiger, there clearly was nothing else. These were Alzheimer patients who had absolutely no way to even... They apparently weren't even aware that a crime had been committed or anything had happened to them. And if the defendant himself hadn't gone and told somebody a scenario, nobody ever would have had any inkling that anything had happened. So it was only what the defendant said, and there was no way to corroborate anything about what he said, whether it was physical evidence or otherwise. Geiger is one of those cases exactly what corpus was intended to protect against or apply to. The defendant went and told somebody, I did this, and there was nobody else who could have said anything about, no, he didn't, yes, he did, this is how it happened. Only his statements. So it was a clear confession. And whether it was made to a police or someone else, I think is not the point. I think it's the nature of the confession. In this particular case, as Judge Jordan pointed out, there was no interrogation, there was no presence of anyone other than the defendant's family members. He was at home. This was a friendly conversation. And I think it's also important to note that the first person who made any reference to sexual activity in this conversation was the defendant. The victim calls and says, yeah, I have a question. I woke up without my pajama bottoms on, and I don't know why. She didn't say, did you do anything to me? Did you take them off? She says, I don't know why. The first thing out of his mouth is, yeah, I woke up before you did and I messed with you some, but when you didn't wake up, I stopped. So he's the first one that brings it up. She didn't prompt him. He admits right off. He also acknowledges that he was aware she was asleep. You didn't wake up. Well, he knew she was asleep when he initiated it. So it's corroboration of her testimony that she didn't know what went on because she was asleep, or she never woke up, or she didn't know what happened while she was sleeping. There's corroboration every step of the way. So the fact that even if trial counsel erred in some way...
And it's your position that because that isn't a confession, that 92, whatever the statute is, doesn't apply at all, and that even if the victim did not testify, there wouldn't have to be anything else we could convict based on his statement alone, because in your view that's not a confession, unlike Geiger. I mean, you just distinguish this case from Geiger.
I think there was also some physical evidence. There was...
From her testimony.
Well, there was evidence of the defendant's semen on the bed sheets, and there was his DNA on her pajama shirt. Now, those alone, without her testimony about her feeling there was some physical discomfort with her not knowing what caused that, I think you needed that. Just the physical evidence of the semen and the DNA on her pajama shirt was not enough. They all worked together. The defendant's statement clearly filled in the blanks as to his initiating, how far he went, his recognizing that she was not conscious while he was doing all these things and therefore couldn't give consent, and he knew she couldn't, she was asleep. There was perfect corroboration of her statements and his, and it put the whole picture together. There certainly was sufficient evidence to prove the trustworthiness of his statement. So even if counsel somehow erred, it was deficient not to object, then he can't show prejudice, because if it had triggered this hearing on trustworthiness, it's clear that the victim's testimony and the defendant's statement corroborate each other.
If the victim came into court and testified that I was sexually battered by this particular defendant against my will, and articulated all of the elements of the crime, and then said, I called him on the phone the next day and he admitted to me that he had sexually battered me. Is that testimony? Is that the kind of testimony that invokes the corpus delicti rule? In other words, before you even get to the statute, you've got to get to the rule itself. A telephone call from a victim where the defendant says, I admit I did the crime, or makes other statements that are inculpatory in nature. Is that even governed by that rule that prohibits the introduction of the statements?
The testimony of a witness relating a conversation that amounts to an admission, that's what I hear you question. Is that what would be subject to the corpus rule? Would there have to be other showing independent of that? I want to say no to that, Judge Torpy. I think that is, and I think that the statute, use of the word in the statute, memorialized, is directly applies to, because it's meant to address the corpus delicti rule. And so I think that it contemplates that these are memorialized statements. It's not now I think any statement has to overcome a hearsay.
I guess I'm trying to understand what the rule is before I have to worry about what the exception is and whether the exception was applicable here and whether counsel should have invoked it. I mean, I thought the corpus delicti rule was a rule of admissibility.
Exactly.
Which simply stated is that the defendant's confession, maybe admission to, is inadmissible until it's been established by other proof that there was in fact a crime.
Exactly.
Isn't that the rule?
That's the rule.
So if the victim gets on a stand and testifies that I was battered, I was sexually battered by a defendant, not necessarily this defendant, then the statement comes in. Right.
And actually, under that scenario, there clearly would be sufficient corpus. I heard your question to be, can the victim or another witness testify to what they heard, is it the statement, the hearsay statement, or the overhearing, or does it have to be?
Let's say he ran out the door and he told a third party that he had just sexually battered the victim. Is that the kind of...
The problem I think that we're facing here with this whole question is it is a matter of admissibility, and it has to be, in order for the court to look to see whether this falls into that whole, the rules of admissibility, it had to have been brought to the attention of the trial court, and it wasn't preserved. There was no discussion about, was there sufficient corpus? What does that mean? When does the statute trigger? Because it was never objected to. It's not an issue that the court needs to examine from that standpoint at this point, Judge Turner.
She's still got time, or we?
I've got 1 minute.
Under the rule, without regard to the statute, if this victim in this case had once she gave the testimony that she gave, has the state satisfied the corpus requirement?
I think the state has satisfied it. There's evidence that a crime of a sexual nature occurred. She didn't agree to any kind of sexual contact. She had physical evidence to show that there had been physical contact of a sexual nature, even if her pajama bottoms had been put back on, although I think it's definitely more stronger that she was naked from the waist down, soreness in the vaginal area, wetness, stickiness. That in itself she knew, and he was the only other person in the house, and they had fallen asleep in the same bed. She was in a different location when she woke up. I think that was sufficient to show that there was a crime of the nature that was charged. It needed more to prove beyond a reasonable doubt for conviction, but that's not the corpus rule. It's not beyond a reasonable doubt. There was sufficient corpus to begin with. So therefore, the state asked that this court affirm the judgment and the sentence.
All right. Thank you both very much.
Just briefly, if I may.
I think I may have misled you, because I was trying to tell you you only had 3 minutes left and you were eating into your rebuttal time, and you used all of your time actually in your initial argument. You don't have any time left, but since I may have misled you, I'll give you another minute. So.
Okay. I view this very simply, the discussion that was just had with the court. The statute that we're dealing with, 92565, subsection 3, and the statute lists this particular offense as being one to which the statute and the requirements apply. Subsection 3, it states very clearly, before the court admits the defendant's confession or admission, the state must prove by a preponderance of evidence that there is sufficient corroborating evidence that tends to establish the trustworthiness of the statement by the defendant. There is no exception.
But this is an exception. That statute's an exception to the normal corpus delicti requirement. Indeed. And it is a lesser requirement. It's a lesser burden on the state than proving corpus, right?
I think it's
sure it is.
Specific to the circumstance where they can't prove an element of the offense. That's what the statute says. Subsection.
We've held that failure to raise a corpus issue at trial is not. You have to preserve that issue. It's not fundamental error. So why would it be fundamental error? Which I think is the point that you're making. That if the issue wasn't raised below, it's not preserved. And how could it be fundamental error? How can you make that argument if we've already said that corpus isn't a fundamental error issue?
I believe because, very simply, that the statute requires this hearing under these circumstances, given the charge that was lodged against the defendant, not only requires the hearing under these circumstances, but requires the court to make specific findings of fact. This court and the other appellate courts in the state have been consistent. When these requirements, when the mandates of the statute have not been met, these cases have been reversed or sent back for new trials. I don't believe that I have not found a single case where the contrary is true. This is required. The hearing was not held. Counsel below did not request the hearing. He stated, I have no objection to the introduction of this admission. So I would contend that that's fundamental.
Thank you very much.
Thank you so much.
Okay.